Good evening. Thank you for attending today's lecture. The topic for today's lecture is a very interesting topic which surrounds a living will. This lecture, the idea for this lecture was given to us by one of our members who in fact approached us and suggested that we have a lecture on this topic, Jamshed Mystery. Thank you for this. And immediately after that, we contacted Justice Sonak, who very willingly said that yes, he would come and address us on this topic. And we also have Dr. Gursahani, who will address us. Before that, I would like our President, Mr. Thakkar, to say a few words.
The Honorable Mr. Justice Sonak, Dr. Gursahani, and all my dear friends. First of all, I extend a very, very warm welcome to Justice Sonak and Dr. Roop Gursahani. And I also welcome all of you, and I am really thankful to you for your time and presence. Bombay Bar Association is indeed very grateful to Justice Sonak and Dr. Gursahani for having agreed to come today to address our members on understanding a living will, autonomy and advanced care planning. Justice Sonak needs no introduction. We welcomed him a little while ago when Mumbai became His Lordship's permanent headquarters, but there is a reason why we have requested His Lordship to enlighten us on this subject. By now it is well known that Justice Sonak is the first person in Goa to have made a living will. And I am sure we will have first-hand understanding of the subject by His Lordship. We sincerely thank Justice Sonak for having accepted our invitation and having agreed to deliver the lecture today. Our other speaker today is a well-known personality who works inter alia in the field of palliative care. He has often said, and I quote, "Palliative care is a medical discipline that focuses more on relief than cure that is essential during the last years of life. There is very little or no awareness about the importance and need for palliative care all over India. Access to palliative care is equally low, and therefore patients who require palliative care often do not receive it." Unquote. In a famous case known as Aruna Shanbag case, the Honorable Supreme Court appointed Dr. Roop Gursahani as one of the panel members of the panel of 3 eminent doctors of Mumbai to report on condition of Aruna Shanbag. So he has in that way connection with law or lawyers or the courts. We are extremely fortunate to have Dr. Gursahani addressing us. Thank you, Doctor, for your valuable time. To show our respect, love and appreciation, may I request our Secretary, Mr. Farhan Dubash, to present a plant to Honorable Mr. Justice Sonak. May I also request Mr. Dubash to give a memento. May I request Dubash to give a plant to Justice Dr. Gursahani as well as a memento. I will now not come in the way of everybody eagerly waiting for Justice Sonak to address. May I request Justice Sonak.
Mr. Nitin Thakkar, the President of the Bombay Bar Association, Mr. Farhan Dubhash, Secretary, Dr. Roop Gursahani, distinguished members of the bar, and my dear friends. Thank you very much for this invitation. I think we have all avoided speaking on this topic for too long. I assure you that I shall try not to speak too long. We are all here to really listen to Dr. Gursahani, whose experiences and knowledge on this topic are legendary. But in courts, we have to hear the members of the bar each day for hours together. I do not claim that I do this rather well, but a captive audience of lawyers as a payback time is sometimes a temptation a little hard to resist. So if I do go overboard or far exceed my allotted time, Mr. Thakkar, please accept my advance judicial directives to pull off the microphone plug. We are all extremely fortunate to have Dr. No, these are advanced judicial directives, yes. We are all extremely fortunate to have Dr. Gursahani with us today. Apart from being an eminent doctor, he is a national crusader, actively disseminating knowledge on this topic and the various medical, legal and ethical issues that are involved. So a combination of an eminent doctor on the days and a generous blend of lawyers off the days is, I think, a very healthy and a lawful cocktail in this iconic bar room, especially on this, thank God it is Friday night. And in such a setting, I am sure that even a dash of a judge, like a dash of salt and pepper, becomes tolerable for a little while. Friends, Mahatma Gandhi always advised us that we should live as if we were to die tomorrow, and we should learn as if we were to live for an eternity. Unfortunately, we tend to reverse the order, and we feel nothing about postponing matters. As judges and lawyers, in fact, we have acquired a notoriety for postponing everything. It can be different with doctors. Generally, as patients, we rely upon their skill to postpone reaching the destination from which no traveler ever returns. But today we want to discuss how good such postponements are once a point of no return is reached, and pointless pain and suffering are the only sure companions until this final destination. As sensations diminish in intensity, the sense of vitality fades. The desire for life gives way to indifference and patient waiting. The fear of death is then strangely mingled with the longing for a repose. Doctors are trained to keep their patients alive as long as possible. Their Hippocratic oath binds them. The oath is that I will not give a lethal drug to anyone if I am asked, nor will I advise such a plan. Therefore, perhaps not many doctors explain or discuss how to prepare people to die gracefully or to die with dignity. And yet for many patients, particularly the old and the terminally ill, death is a question of when and not if. Therefore, should not the medical profession rethink of its approach to these life and death issues? And if so, in what way? And if the medical profession is prepared to rethink its approach, is the legal profession geared up to back this approach? Is our present state of the law equipped to deal with these issues? Are there any judicially manageable standards to effectively address these issues? Is it not high time that the legislature steps in? Friends, philosophical questions aside, real practicalities call for meaningful discourses and discussions if some broadly acceptable solutions must be found. These questions have become increasingly relevant with aging populations medical innovations focus on dignified living and not merely survival, and spiraling hospital costs. Permit me, therefore, to touch on some basic concepts associated with today's topic. Friends, all this stems from the concept of euthanasia. And euthanasia means intentional, premature termination of life of another person at her request to cause good death. That is how euthanasia has been described. Now, active euthanasia means causing the death of a person with her consent by direct medical intervention. As of today, this is not permitted, but this is the meaning of active euthanasia. Some positive act on the part of the person causing the death is necessary. Passive euthanasia means withdrawing or withholding life-prolonging medical treatment following the express or implied will of the terminally ill, brain dead, or permanent vegetative state patient, resulting in her death. Voluntary euthanasia means terminating the life at the request of the patient, and this is where the concept of a living will comes in. While a person is in a state to take a decision, in advance he gives certain directives concerning himself, and that is simply what we call as the living will or advance medical directives. So voluntary euthanasia means terminating the life at the request of the patient. The request may be made before contracting the illness or even during the course of the illness. Non-voluntary euthanasia means terminating the patient's life without the patient's consent. This may be for the patient's good or on a proxy request when the patient is not in a position to express her views. Sometimes the relatives, the next friend, takes the decision and says that, okay, I am giving a consent to now stop further treatment. So that is called as a non-voluntary euthanasia because the patient himself is not in a state to give any decision. Now, but this is different from involuntary euthanasia, which means terminating the life against the patient's will. This is a strict no-no. You cannot do that. Now, in the legal world, this topic of active or passive euthanasia somehow got linked with the topic of suicide or attempted suicide. In Maruti Shripati Dubal's case, our High Court, a division bench of our High Court, speaking through Justice P.B. Sawant, struck down section 309 of the IPC that had criminalized attempt to commit suicide. You all know that attempt to commit suicide was a crime under section 309, and there is a corresponding section in the new penal code as well. Now, so the court reasoned that the right to live guaranteed by Article 21 of the Constitution included the right not to live or right to die. The court also found the provision to be arbitrary on the ground that a person who attempts to commit suicide needs medical help and not some jail term. Now, in Ratinam's case, a division bench of the Supreme Court, speaking through Justice B.L. Hansaria, approved this view in Maruti Dubal. In Gyan Kaur versus State of Punjab, the appellant who was convicted under section 306 of the IPC, 306, as you know, deals with abatement or abetting the commission of suicide. Now, she was convicted under section 306 and she argued before the Honorable Supreme Court that section 306 of IPC was ultra-virus and unconstitutional because if attempt to commit suicide is no longer a crime, how can abatement to commit an act which is not at all a crime be regarded as a crime itself? Now, this was an ingenious argument, and the larger bench of Gyan Kaur was forced to revisit the decisions in Maruti Dubal or R. Ratinam. In Gyan Kaur, the Supreme Court overruled Ratinam, which had said that a right to live includes the right not to live or the right to die. They said that this was a very wide proposition and they did not accept it. However, in paragraphs 24 and 25, the court observed that the right to life, including the right to live with human dignity, would mean the existence of such right up to the very end of the natural life. So this was one observation made in paragraph 24. And they also held that this includes the right to a dignified life up to the point of death, including a very dignified procedure of death. In other words, Article 21, the rights of Article 21 would also include the right of a dying man to die with dignity when his life is ebbing out. In paragraph 25, the Supreme Court clarified that the debate regards physician-assisted termination of life is inconclusive. Now, in Aruna Shanbag's case, which was referred to by Mr. Thakkar, the Supreme Court, specifically referring to paragraphs 24 and 25, held that the debate over permitting physician-assisted termination of life was inconclusive and therefore no final view was expressed in Jian Kaur's case. Aruna Shanbag's case explained that active euthanasia, which involves the administration of a lethal dose to a patient, is a crime in the present state of legislation in India. However, non-voluntary passive euthanasia, which involves the withdrawal of life-saving measures, is permissible even without any supporting legislation, subject to certain conditions, safeguard and procedure, which in fact the Supreme Court devised or introduced in the said decision. Now, Dr. Roop Gursahani, as Mr. Thakkar has told you, was one of the 3 experts appointed by the Supreme Court to examine Aruna Shanbag and not only report on her medical condition, but also to offer suggestions on the best course of action that could be adopted in such cases. The Supreme Court has acknowledged the service rendered by these medical experts, including Dr. Roop Gursahani. Now, the decisions in Ratinam, Gyan Kaur and Aruna Shanbag were analyzed and commented upon by the Constitution Bench in its landmark decision in the case of common cause. The Constitution Bench acknowledged that the subject of active or passive euthanasia or advanced medical directives, which is the same thing as living will, should be best addressed by the legislature. However, in the absence of any legislation, the court felt that these topics were far too important to be kept in a state of a limbo. Accordingly, the Constitution Bench, by invoking their powers under Article 142, declared that voluntary and non-voluntary passive euthanasia was permissible, no doubt subject to certain terms, conditions and safeguards. So that is presently the state of law in the country. The Constitution Bench held that passive but not active euthanasia could be permitted for patients who are terminally ill, in a permanent vegetative state or brain dead without any hope for revival. The court ruled that even voluntary and even non-voluntary passive euthanasia is permissible. Further, the adults in their conscious mind can execute a living will. This is where they introduce the concept, a living will, in the form of advanced medical directives directing them not to prolong their lives by pointless medical treatment. If I could just pause here for a minute. See, what happens is that it is unfortunately a fact that we really do not like to discuss on these issues, and therefore we are completely unprepared for the end of life scenarios as may unfold. And usually these scenarios do not come with any great warning. It is unfortunate, but it is a fact of life. They say that in fact only 2 things are certain in this world. One is death and the other is taxes. So, once this situation develops, many a times it is really impossible for the person who is going through this situation to take any decision. He is not in a state to take any decision. Neither are the relatives, the children or the parents or the next friend, in a position to take decisions, because these are very, very sensitive matters. Similar is the fate of the doctors. On one hand, the Hippocratic oath binds them to try till the last, try unto the last, and there could be several legal complications in case they take any decision by themselves. So to avoid such a situation, the concept of living will or advanced medical directives has evolved. While you are in a state, while you are in conscious mind, when everything is fine, you could execute a living will in which you could give advanced medical directives that should such a situation arise, then this is what is my desire, or this is what I want to happen. I want it to unfold. Now the Constitution bench not only acknowledged that this could be done, said that this could be done, but they provided detailed safeguards and guidelines which should govern such matters until a legislation is enacted to cover this important field. Chief Justice Deepak Mishra's opinion at paragraphs 198 to 200 lists the detailed procedure and the safeguards. It deals with the competence of adults to execute an advanced medical directive or an AMD. It deals with the contents of such AMD. It deals with how the AMD should be recorded and preserved, and when and by whom it can be given effect to. It deals with the constitution, this is most important, it deals with the constitution of medical boards and judicial review where the medical boards decline permission. Now suppose there is a living will made and it is handed over to a physician or to a doctor. It is not as if the doctor can by himself act on that living will. This judgment contemplates that every hospital has to first constitute a primary board. The judgment gives the composition of this board, the tentative composition of this board. It is for that primary board to opine that a situation or a situation of no return has been reached. Really, this person has no chance of coming back, or is in a permanent vegetative state. Now, even the opinion of a primary board is only a preliminary opinion. Even based on this opinion, the hospital or the doctors cannot act, they cannot act on your living will. The moment the primary board opines that yes, such a situation has been reached, the matter will have to be referred to a secondary board. The Supreme Court has provided the constitution of a secondary board, which comprises of doctors who are more experienced, and it's a board which is, in a sense, more high-powered. Now, if the secondary board also concurs with the opinion of the primary board, it is only then that the doctors can act on your advanced medical directives, and that too after giving an intimation to the jurisdictional judicial magistrate first class, and also reporting this decision to the jurisdictional high court. The high court is expected to keep these decisions in a digital format and not to destroy this information for at least 3 years from the demise of that person. So broadly, this is the procedure provided. I really would not go into the details of several things, like for example, the will should be executed before 2 competent and independent witnesses. It has to be executed before a notary public or a gazetted officer. Thereafter, once it is executed, it has to be handed over to a nodal officer, which is to be appointed by the government. The nodal officer can be an officer of the local authorities, or it could be some government servant itself. They have to maintain a directory as a record. They have to maintain a repository of all these advance wills, and so on. There is a lot of nitty-gritty which is provided. The judgment also says that the advance will should record, and it should be made clear that it is revocable at any time. It's not as if the will is once made, it is made forever. A person can always change his mind, and specifically it is revocable. The Supreme Court has also said that the witnesses and the notary or the gazetted officer should record that at the time when this will was made, I found the person making this will to be in his right senses and able to take an informed decision, and so on. So these are the safeguards that are provided. And in the living will, a person can also indicate the names of his close relatives or next friend to say that if such a situation arises and a consent has to be given, then these are the 2 persons or the 3 persons who I authorize to take a decision on my behalf, and so on. Now, there is one more aspect. Now what happens where a primary board says that yes, according to us, the will can be given effect to, but the secondary board does not agree with the primary board. Now the Supreme Court has said that in such a situation, the only remedy available to the relatives of that person or to the hospital itself or to the treating physician is to petition the High Court under 226. But fortunately, the Supreme Court has also provided, they have not said that you have to do it, but they have said that the High Court can also constitute a medical board comprising of doctors who have even greater experience. And normally, we would go by that naturally, because these are, I personally believe that these are not matters for which there are judicially manageable standards. We interfere, or we would interfere only if there is no option and if the position is quite clear. But the High Court has been given the liberty to constitute an independent board and decide the matter. Now what happens in a situation where there is no living will at all and a situation is reached where the patient is at a point of no return or is in a vegetative state or is brain dead? Now in such a situation also, the treating physician or the hospital that has been given the liberty to constitute a primary board and follow the same procedure. But the only difference is that these boards will then interact with the relatives of the patient and see whether any consent is forthcoming. If the consent is forthcoming, then the situation is all right. If the consent is not forthcoming, there are observations which say that you can approach or you can invoke the 226 jurisdiction, but I really do not know what would be the fate of this kind of a proceeding. But that option is also there. So in short, this procedure of having an advance medical directive is recognized and to a certain extent, or to a great extent I should say, legalized by the decision in common cause. And this decision in common cause, certain guidelines or certain directives were modified based on an application by some, I think, society of, I do have that judgment, but by the Indian Society of Critical Care Medicine. Because the earlier directives involved going before a judicial magistrate, executing the will before the judicial magistrate. It involved greater amount of bureaucratic procedures which have been done away with by this modification. The Supreme Court has made an attempt to simplify the procedures as was possible. I won't say that they are completely simplified, but to the extent possible, because the Supreme Court also had to strike a balance. To make it too easy would leave it open to abuses, and at the same time some safeguards were necessary. So that's how it is. Now presently, dear friends, there are very few controversies on this issue of advance medical directives or the living will, given the clear and exhaustive judicial directives of the Supreme Court. The states or the state governments are, however, lagging in notifying custodians, nodal officers to keep such wills or to maintain a repository of such wills. There is also some time lag, or there is also some lethargy when it comes to constitution of these primary boards or secondary boards. In Goa, this exercise is substantially completed. A panel of doctors is also in place to facilitate the immediate constitution of such boards. But the work on a digital directory is still in contemplation and is yet to be completed. Now, the Indian Medical Association, Goa chapter, and our Goa Legal Services Authority worked on this, brought all the various government agencies and other stakeholders to a common table, and has operationalized this process substantially. And it's just a fortuitous circumstance that I was given the option. I always wanted to have a living will, but I was told that no, you should be the first person who should execute this will, simply because there should be more dissemination on this subject. There is lethargy from the administrative side, but what is really more important is that we discuss on these topics, we know about these options, and then of course we take an informed decision. Now, a broad-based consensus is reached or is reaching on the issue of passive euthanasia. As the law stands today, passive euthanasia is permissible, whether it is voluntary or non-voluntary. However, active euthanasia or legally assisted suicide is still a very controversial and a sensitive issue. This discourse must continue until medical, judicial, and legislative consensus is reached. The proponents of euthanasia defend it on the principles of autonomy and choice. They argue, this is my body. Who is the government or who is the society to dictate how I should deal with it? This is one of the arguments and one of the prime arguments. They argue that when dying cannot be avoided, let us be passionate and tolerant enough to respect the choice. They say that this is not an issue of right to die, but this is an issue of right to live with dignity. In one of his addresses, the famous Oliver Wendell Holmes quoted a line from a Latin poet who had uttered, "Death plucks my ear and says, 'Live, I am coming.'" That is the significance of living. But when a patient does not know if she is living until death visits her, and there is constant suffering without any hope of living, should one be allowed to wait? Should a patient be cursed to die as life gradually ebbs out of her being? Such futile waiting, they say, mars the pristine concept of life, corrodes the essence of dignity, and erodes the fact of eventual choice, which is pivotal to the right to privacy. Passive euthanasia is accepted on the premise that there is no point in prolonging a patient's suffering once the medical opinion has certified that a point of no return has been reached. Then on the same premise it is argued, what is the logic in excluding active euthanasia? Active euthanasia supporters argue that the patient's best interest principle, that is what the doctors are to be guided by, must be extended to legally assisted suicide or even administering a lethal injection to put an end to the patient's pain and suffering. It was, I think, Napoleon Bonaparte who famously remarked that death is nothing but to live defeated and inglorious is to die every day. Now, these are all very weighty arguments. On the other hand, there are equally weighty counter arguments. The sanctity of life doctrine, the Hippocratic oath by which the medical professionals swear to do everything within their means to save a life unto the last. There are arguments about prognostic uncertainty and misdiagnosis. There are problems with what is really in the patient's best interest. Would not the hospital or the clinic costs cloud our decisions? Could it not be that the relatives opt for a speedy exit, not because it is in the patient's best interest, but to save costs, or worse still, to speed up the inheritance of the patient's property. Then there is always the slippery slope argument. Once we permit active euthanasia, we are bound to slide down the slope, and we may be powerless to resist other inevitable consequences like the elimination of the disabled, the weak, the infants, and so on. The slippery slope arguments often point out to the horrific consequences of the Nazi philosophy of eugenics and the predominance of the master race. Peter Singer warns us pithily that once we adopt a system that permits the killing of patients, we will not be able to limit the killing to only those who want to die. The right to die can so easily become an expectation to die, and finally even a duty to die. All these arguments and counter arguments do not admit of any easy answers. Friends, as a judge, I rarely have the luxury of raising so many questions and going away without the compulsion to answer the same. I must thank the BBA for extending this luxury to me today. But it is very important to have such sensitization programs so that some answers could emerge or evolve on these difficult issues. I read somewhere that status quo, which we often order in the courts, is the Latin phrase for the mess that we are usually in. But jokes apart, most people tolerate the status quo simply because they lack the courage to pilot change. Piloting change involves assuming responsibility, and most people dread responsibility. Once such facts and figures, viewpoints and counter viewpoints, arguments or counter arguments are objectively placed before the people, some consensus is bound to evolve. The solutions may not be foolproof, but they would be far better than those that are grudgingly offered today. Ultimately, democracy is based on giving the competent adults access to all relevant information on the subject and then trusting their ability to decide for themselves. Friends, I have taken enough of your time. We are all eager to hear Dr. Gursahani, a national crusader on this topic. He will have much to say and much to share. Friends, wise men like him speak because they have something to say, and fools like me speak because they have to say something. So once again, I thank the BBA for inviting me. I thank this distinguished audience for bearing up with me, a phrase which I really detest when said by you all in the court. But thank you very much, and Jai Hind.
Thank you very much, Judge. It was a very, very insightful guidance to all of us. And may I now request Dr. Gursahani to address. To be careful.
Right. I'd like to begin by thanking Justice Sonak for thinking of me and Farhan for actually putting it together. And of course, to all of you for being here today. Now the moment of truth. Yeah, there we are. So, a minor correction, I'm actually a neurologist and my day job is headaches, paralysis, epileptic seizures and so on. And palliative care is a kind of a newly found passion. And a personal connect, my career actually began as a neurologist thanks to a judgment by Justice Lenton. So, if you look at the whole cascade of judgments on medical postgraduate admissions, Gursahani is number 1 or number 2, and that was run by my uncle, argued by my uncle, Nari Gursahani. So, if I hadn't been a doctor, I would probably have been sitting here. Right. I'm sure most of you can see this, and I'm just going to read it out. These are two paradoxes. In Hindi, that thing that turned up on my Twitter, जन्म और मृत्यु अब महंगे हो गए हैं, सीजरियन के बिना कोई आता नहीं और वेंटिलेटर के बिना कोई जाता नहीं. And on the other side, billboard on a double-decker in London, if tomorrow everything changes, leave no doubt. And that's to talk about advanced care planning and advanced medical directives. So, Justice Sonak has already said this. Think of the last journey of your life. The destination is fixed. And really, the choices that we have is, what do you want your experience of your last illness to be like? But before that, all of us need to understand what this last journey is like and what kind of flavor you can expect. So many of us imagine that we are going to die suddenly in our sleep and wake up the next morning listening to either Bhimsen Joshi or Queen or whatever your choice is. But that unfortunately is not something that is likely once you have crossed the age of 50. And the likelihood that somebody will die suddenly after that is just about 7%, well under 10%. And of course, you know, our long-haired president had a lot of punya, which is why he died literally speaking. And he was gone in an hour at the age of 84. Pretty unusual. The next mode of death, which typically is peaks somewhere in the 60s, is cancer. Causes about 20% of all deaths, and the numbers are probably declining. And most people with cancer typically have a pretty good functional level until a certain point that the cancer fails the second, third, fourth chemotherapy, and you enter what is called the waterfall trajectory. After an inflection point where cancer biology then drives everything. And when that happens, you can predict their death fairly clearly. So if you look at, and people retain function till very late. For instance, Manohar Parrikar, this photo was taken barely about a few weeks before he died. And he was still going out inspecting projects with a tube inside him. He was functional. That is the difference from the next categories that I'll talk about. One of our former chief ministers died of liver failure. Now, when somebody has bad hypertension, diabetes, multiple other things, organs start to fail, and this peaks in the 70s. And we call this the looping trajectory because people come in crisis into hospitals, never are as good again, and this entry, re-entry, finally in a crisis, they are carried off. And then, of course, you have those of us who are virtuous and reach our 80s, and that's going to be more than 50% of us. And these are the deaths that are caused by frailty and dementia. It's called the dwindling trajectory because you reach a fairly low level of function and then kind of hover around at a fairly low level until the end is reached. Of course, there is an artifact, and that is partly to do with the sudden death. These are people who are rescued by an ICU, and the numbers vary depending on where you are in the world. Once somebody ends up in coma, say longer than a day, the likelihood that they'll come back normal is 0. Most people will improve, if at all, only with disability. Many will die, and those who survive, a good proportion of those who survive will survive like Aruna Shanbag. Not a very good state. So, if you look at these trajectories, you will understand that for about 90% of us, death is actually predictable. Forget that the upper one, because that can go on for a long period of time, but that's, as I said, a very small number. So, somewhere like if you take the cancer, if you take the other two trajectories, which accounts for more than 90% of us, death is predictable some weeks or months before it actually occurs. That's a point that we all need to remember. And then comes the question of how do you ensure a good death for yourself or for your loved ones. And again, Justice Sonak alluded to that because there's a huge component of autonomy in that. And the first is knowledge, to know when death is coming and to understand what can be expected. Because for many people, being able to say goodbye, to close their accounts, to ask for forgiveness, give forgiveness, complete all of that is very important. If that isn't done, then they feel cheated. Obviously, control, dignity, privacy are all important, and then you also need pain relief and symptom control. The middle one is where you are involved. So if you think of the last journey of your life, who has the information, who is planning, whose responsibility it is to plan? Well, foreseeing and foretelling were always the doctor's responsibility. Unfortunately, given the fact that talking about death is considered upshakun, most doctors' policies don't ask and don't tell. So the ball literally, for all of us as citizens, is in our own court. It's about our own decision making. So if you look at who is planning your last journey, it either is you or someone you trust, because the default mode is that nobody plans. And when nobody plans, that is when the worst suffering happens, because there's nobody able or willing to make decisions, and things can go on and on until eventually irresistible technology and immovable biology crush a human soul in between. And if you can take charge, if for instance palliative care comes in, then suffering can be minimized. So just to explain to you what palliative care is really applicable to all kinds of serious health related suffering. Originally it began to deal with the sufferings of cancer, but then from the 1990s onwards it grew to all kinds of suffering, health related suffering, and neurologists started to get involved only somewhere in the 2000 onwards. So in fact this is something that I really picked up only well into my 50s. A couple of other terms to remember. Terminal illness means that weeks or months before death, the process becomes irreversible, and when that is understood, curative treatments can effectively be stopped. Eventually you reach a stage where nothing will work, and that is called actively dying, and the pressure falls, people become unconscious, and that can be days to hours, maybe as long as a week. And that is where, in both of these situations, we embark on what we term as end-of-life care. And end-of-life care is defined as the last 6 months to 1 year of life. Now, this obviously is retrospective very often, but in the US and in other developed countries, because governments are legally bound to provide end-of-life care at the location of your choice, it becomes important to actually determine if somebody is possibly within their last 6 months or a year of life. So it takes a certain amount of medical judgment to do that. Right. But the point to remember is that throughout the journey, if you can speak coherently, it is your decision, and your choices and decisions come first. Nobody else is involved. Absolutely nobody else. It's only when you cannot that you need to pass this responsibility on to somebody else, and you need to prepare for that. So just a question, is it possible to pass away comfortably at home? Yes, US presidents do it all the time. Jimmy Carter is at home. He's now in a wheelchair. He can barely speak to anybody. These two pictures are of George and Barbara Bush. And this is fully financed by the government in all developed countries. So whose responsibility is it to plan? Can you decide right till the end? Well, remember that as you kind of go down this journey, once the active dying process begins, then people are not fully conscious. That is about, usually in cancer, it is right at the end. In organ failure, people cycle in and out. But the problem is dementia. And there, people can lose capacity up to a decade before they actually die. So when does the process become terminal? That's where often the catch lies. We talk of autonomy. autonomy is the right to determine my own future, to accept or decline any therapy, to decide who decides for me. Is this absolute? In some ways, yes, you could say it's a Western concept, but I don't agree. Even in Asian societies, we do believe in relational autonomy. The Indic word for that is swadharma, where you decide together with people around you, but you are the prime mover in your own story. So when you do this and you start preparing to ask people to stand for you, ideally you have to have three decision makers. They are not a committee. If the first is not available, then the second comes in. If the second is not available, then the third comes in. Many people don't realize this, but when in practice, only one person signs out. The next decision that has to be taken, and this is something that is the individual's choice, and that is the location of care. Hospital could be in the ICU, but no intensivist, no ICU doctor I know wants to die in his own ICU. Right? And think of it, lights on constantly, there's noise all around you, and strange masked creatures are doing painful things to you. Don't want that. Hospice is a good option. Unfortunately, in India, hospices they're only now that they're beginning to come up for non-cancer diagnosis. Otherwise, hospices were only for cancer. But the ideal place is home, if you can manage to organize this. And you actually go to hospital or to the ICU only if you want to get these life-saving treatments, which you have the right to refuse any or all of them. Remember that in many patients, they do save lives, but in those who are dying, they only prolong the dying process. And these include cardiopulmonary resuscitation, the ventilator, fluids, artificial tube feeding, which often becomes a difficult psychological decision for the family to remove. Dialysis, chemotherapy, yes, all of these you understand. So the living will essentially is a document which you can use. Unfortunately, that document alone has been proven to be ineffective because it requires both a process and a system to make it effective. The system is called advanced care planning, and actually it stands for death literacy. Like we have health literacy, we need death literacy. We need to understand what the last days are like. So this process guides decision making about your healthcare if and when you do not have the capacity to decide for yourself. It has to begin with a conversation between you as the individual, your family and your appointed agents, your healthcare providers. Ideally, this is run by facilitators or counselors who are trained in this. This has to be included in your medical record and then a system to see that this is acted upon. So basically, you need a proxy decision maker and guidance for the proxy decision maker, which basically talks about what type of life, what level of care, what you hope for in the face of illness, and all that comes together in the living will. So just to let you know that these are terms and definitions that all of you are now going to be, over a period of time, more and more familiar with. ACP, as I said, is the process of considering and communicating personal values and goals related to medical care over time. The healthcare power of attorney is probably the single most important component of this. Appointing an agent to make future medical decisions, and it only becomes effective when the patient becomes incapacitated. This is the designated option, because if you have not put together a designated option, then the default option works by a hierarchy in terms of your family and so on, which starts with a spouse and then adult children, then siblings, parents and so on. So that is the default option, and almost all jurisdictions in the developed countries have this done by legislation. In India, the only place where this has been thought about and is up in the public space is in the All India Institute of Medical Sciences. So we use that because that has had some process going into it. And if you ever run into this bit of conflict about who is the surrogate decision maker, if the person has not been designated, then that is probably the only resource we have at the moment. The Advanced Medical Directive is the document that describes both the preferences and the appointment of a surrogate. The living will can be boilerplate, it can be individualized, you can talk of what you want, what you don't want, how you would like your funeral to be, and so on and all that. But you can understand, much of this will depend on the person who carries it out. But just before death, when, say for instance, somebody is found unconscious, what do you do at that time? whether it is in hospital or at home, you need actual orders which spell out. If I am found down, let me be in peace. If I am found down, move me to hospital immediately and put me on a ventilator if need be. If I am found down, well, see that I am made comfortable. Those are things that actually need to be spelled out when somebody is in the last 6 months to a year of life, and those are documents that we are beginning to work on, because until we go through this earlier part of the process, we really can't get there. Something that I like to point out to lawyers is that we got lucky in 2018. But looking back at it, effectively, this was the Supreme Court of India actually hauling the liberty of our constitution into the personal space through this triptych of judgments. Now, if you look at it, the first and the third have had so much of litigation around them. The middle one, where? Where did it vanish? Because there was no lobby, there were no interested parties. The patients don't know what to do about it. And I'd like to point out again that Justice Mishra made this absolutely clear. All adults with the capacity to consent have the right of self-determination and autonomy to refuse treatment. Where a patient has already made a valid advance directive which is free from reasonable doubt and specifying that he or she does not wish to be treated, then such directive has to be given effect to. I'm sure as lawyers this will be parsed and analyzed further, and the operative word is valid, right? So I'm sure we are going to have some litigation over a period of time. Something that my colleagues, doctors, don't understand, and that is the fact that where we often look to the legal community to guide us, is that neither of us operates in a vacuum. We have ethics and constitutional morality. Those flow down through judgments which are basically principles, and laws which are implementation. I mean, it's only laws that can say thou shalt not, thou shalt, on the pain of, and so on. So, but these are based on a bedrock of public awareness, practice, guidelines. Over a period of time, these will evolve. In fact, if you look at it, the constitutional morality, the judgments are now in place. We have that basic framework done. It's now a matter of us actually making all of this workable. Unfortunately, I'd be amazed if I got an audience of doctors as involved and as full as this. Really. Doctors tend to shy away from this. If you are a patient or a patient's relative, you will think these are perverse incentives. That you put a patient into a corporate hospital and suck the money. So there's a joke that I've heard that says that a corporate hospital is one where the poor cannot enter and the rich cannot leave. But actually that is not so. What doctors feel is that there is no legal clarity about this. No clear regulatory requirements, and the fear of criminal charges and litigation. This is urban legend. When you do this, if you do the right thing, the fifth son from the US will turn up and accuse you of having killed his mother with his eldest brother. So these decisions, and that is often the kind of excuse that doctors often make. But really speaking, there are difficulties. One difficulty is in establishing prognosis, but the biggest difficulty, the elephant in the room which nobody addresses, is that we do not know how to deal with these situations. We are not taught this when we train. It's only now that it is being included into the medical curriculum, and we absolutely do not know how to talk to patients and families about this. Do not. Really, we do not. It's surprising. You see for yourself, if you had somebody seriously ill in the ICU, and watch senior doctors, wiggle away and try and escape. Because they just don't know how to address this topic. So we're working on that. Anyway, that's a different matter. So when do you make a living will advanced medical directive? Ideally trigger events when you have a new diagnosis, somebody goes into hospital, if there's a change in care need, somebody becomes dependent, but actually it's any time. Like an estate will, it always seems too soon until it is too late. So anytime. Just look at this trajectory of anybody's life. When you are well, as you begin your 60s or 70s with illnesses, and then enter the last year of life. So we look at all of this as an umbrella term. Advanced care planning is an umbrella term. It includes what I've already spoken about, but look at this, it also includes organ donor registration. That's also part of the same thing. And we need to put it all together. Now you would say, why would you do advanced care planning for the healthy? You know both of these guys? Barack Obama and Michelle Obama, at the end of somewhere in his first presidency, announced that both he and Michelle had made their advanced medical directives. Why would a 48, 49-year-old guy do that? Because, well, the US president has an occupational hazard of being shot in the head. What about Schumacher? You'd think he'd never have thought of that through his racing career. He amassed all those millions, and 2 or 3 years after he's finished his racing career, a stupid skiing accident where he literally just toppled and cracked his skull on a rock. He is not known to have walked independently since then. I'm amazed that he never put this together. So for anyone, young and old, who's worried about catastrophic brain injury, well, this is something that people do need to think about, but typically that's something that needs to be thought through a little carefully. You have to understand how these would become operative, not that easy. For seniors, if anything bad happens. Now, I had this patient who had this whopping brain hemorrhage, and sure enough, we operated on her. She was well in the sense that she came out, she could eat with her right hand, she could speak, but she was completely paralyzed, stuck in a wheelchair, and she hated it. And she made that very clear. Why did you have me operated? She said. So her sister, who recovered from a heart attack, decided that she was going to make her preparations well in advance, and she actually wrote out her living will. Then, of course, when somebody is towards the end, they would perhaps be able to spell it out a little more in detail. This was another patient who had bad lung disease, but yet, I mean, he required oxygen all the time, but yet he wanted to attend his granddaughter's wedding the next year. So he made a clear will which said that if he ever ran into a problem, if he needed a ventilator, as long as it was for 3 to 5 days, he was willing to do that because he wanted to attend the wedding. But if his heart stopped, it was very clear, let me go. So these are the things that people need to understand, and that's why some of this documentation will essentially require medical inputs. And that is why this is going to be a joint endeavor between doctors and lawyers. So this is the advanced medical directive that my group has put up. It's available on multiple websites, and this is, I think, the one that the Goa group also drew upon. So if you look at it, it begins with somebody who is an adult, who is in sound mind and has decision-making capacity. If one of these situations comes up where they have reached the point of no return, or in a persistent vegetative state, or you can understand, I mean, 3 different situations that they could reach. Then going by what the Supreme Court had said, a panel of 3 doctors should actually opine on this, and then if any of these treatments are instituted, you can tick off those that you would want withdrawn or whatever, or there is enough space to put down your own wishes and so on. But the important point is, and something that you people might want to remember, is that when the surrogate or the proxy is appointed, the person has the right to either allow them discretion or only allow them to monitor the process. So do they have discretion or not is something that actually needs to be spelt out for the healthcare proxy. And as I said, it needs to be ideally 3, but at any given time it is the first one available who makes the actual decision. The one thing to remember is that a living will is made in writing but can be revoked orally. So if I see a patient who's conscious And in a situation like this, and I know they have a advanced medical directive, I'm supposed to ask them, this is your advanced medical directive, do you still want it followed? Even if the individual is confused, but says, no, I will follow that directive to revoke it. So there have been instances in the US where the family has been aware that the patient is no longer in sound mind when revoking it. But that doesn't matter. It can be revoked orally. Right. So elsewhere in the world, it just takes one or two witnesses. There are only a couple of US states that actually require notarization. But at least for us, it has made it very much simpler compared to what the earlier system was to work with just two witnesses and either a notary public or a gazetted government official. Of course, we need to put it up into the designated custodians, but I always ask my patients to make 5 copies. One goes into the medical records, at least 3 go to the surrogate and the family and the doctor, and 1 is stuck up on the fridge. Most accessible place. Make sure that everybody who needs to know is informed, and important to remember that doctors and hospitals may not be aware. So the patient has to educate them. In fact, my patients with dementia land up in the casualty in in emergencies, and the relatives and the family is informed. Don't let them put tubes into her. Check with me, or at least tell them to just give intravenous fluids and just push it along until, there is time for everybody to think. Because the default option is tubes, and into the ICU. And very often, you need to have that stopped. So there are multiple sites on which this document is available. This document is, in a sense, a preliminary document. Vidhi Legal Policy and my association, the Indian Association of Palliative Care, we have a memorandum of understanding to put together a whole suite of documents over a period of time. So those will come out into the public space, hopefully in about 6 months. So I've already told you that if the individual concerned changes their mind, the whole thing can be revoked instantly. But for it to work, everybody has to start talking. And one place to look up, the way to begin these conversations is something called the Conversation Project. We don't have it in Indian languages. Again, some of us are working on that. Hopefully, we'll have this up soon too. But I'd like to end by these examples. Why do we need this? Because we now have the means to keep the body alive indefinitely should we choose to do so. Barbara and George Bush died in April and November 2018. In their own beds, literally in Darbar, surrounding by dogs, cats, grandchildren, the whole works. And there are enough pictures of them. Atal Bihari, in between the two of them in August, died in the AIIMS ICU in intensive care for about 2 weeks. In the last 1 week, he was on something called extracorporeal membrane oxygenation. That means heart, lungs, everything taken over. Think of it. It's almost obscene. A 95-year-old at the end of his life, until finally he passed away. And of course, we have the example of Lata Mangeshkar, who got intubated, meaning those incomparable vocal cords, tubes being pushed into them, not once but twice. 95-year-old COVID, what do you expect? I mean, at some stage, it is time to make her comfortable and let her go. So I have a dictum which I tell everybody. I hope you're not an Indian VIP because you will be tortured to death. Thank you. I'll put this off. Yeah, I know.
Can I shut this?
Yeah, put it on.
Thank you, Doctor. And thank you, Justice Sonak. This was a very informative session, especially for a Friday evening. At least from my side, and I'm sure all of you also have learned something which otherwise we would not have dwelled upon. And I hope that we all take this information and use it for our betterment. Thank you all of you for attending today's lecture in such large numbers. We have snacks and tea, coffee arranged for you outside. Please have something before leaving. Thank you once again.